Hello, are you looking to protect your unique invention? Do you want to know how to secure a patent in India? Well, you have come to the right place. Today we are going to walk you through step-by-step process of registering patent in India. So let's dive in and turn your brilliant ideas into protected intellectual property. But before we begin, it is important to understand what are patents. Intellectual property, as defined by patent law, is tangible and based on individuals' intellectual knowledge and innovative spirit. It provides for a source of livelihood for innovators in intellectual property rights and innovative industries. Creators can earn royalties, sell their inventions, and start their own businesses by allowing companies to use their invention, granting them potential for wealth and success. Protecting intellectual property rights is a crucial fostering for innovation and creativity. Under Patent Act of 1970, individuals and businesses in India have the opportunity to secure their inventions, safeguard their innovations, but also grants them exclusive rights to exploit their own creations for a specific period. If we talk about the registration process of patents in India, it can be divided into broadly six major steps. The step one includes patent search. Patent search is the first step of patent filing procedure in India and is conducted worldwide to determine the novelty of an innovation. Generally, it is considered to do the patent search before patent application filing. If an invention is found in prior art or closely resembling any prior arts, then the novelty of that invention can be challenged by Indian Patent Office and the application can be objected to. Therefore, it is important to perform prior patent searches to assess the chances of your patent getting approved by the patent office. The step 2 is drafting patent specification. After conducting thorough searches worldwide, the specification of the invention is written in a techno legal language with or without inventor's claim. Without claims is a provisional specification and with claims is complete specification. The specification outlines the field of invention, detailed description of the invention with working examples, and the best method to use the invention so that when it comes to the knowledge of a person skilled in the art, it can be easily used. Legal protection to the patent is granted when the specification is drafted with inventor's claim and is complete. Step 3 of the patent filing application is related to actually filing the application. After drafting the patent specification, you can begin the procedure of filing patent application in India. As we discussed earlier, based on specification drafted, the drafted provisional or complete specification is filed in Form 2 while patent application form is filled in Form 1 as prescribed by Indian Patent Act. If provisional patent specification is filed, then within 12 months of its filing, a complete specification has to be filed with inventor's claims. There are 6 different types of patent application forms which can be filed on the basis of their purpose. These are ordinary patent applications which are used for filing patent within the territory of India. PCT National Phase, which is Patent Corporation Treaty of National Phase application, Patent Corporation Treaty International Patent application, Convention Patent application, Divisional Patent application, and Patent for of Additional application. These are the 6 types of patent application that can be filed in India. Step 4 of the patent application is patent publication for public opposition. Once the patent application process is complete, then after expiration of 18 months of the date from the date of patent filing or date of priority, whichever is earlier, the patent is published in an official journal and is open for public viewing and inspection. This provides for an opportunity to general public to raise an objection to the patent on valid grounds. The step 5 of the application involves requesting patent examination. The patent application is examined only when a request for examination has been filed. The request for examination has to be filed within 48 months of the patent filing date or date of the priority. The patent examiners examines a patent application and issues an examination report. The examination report contains a series of objections raised by an examiner. The response to an examination report has to be filed within 12 months of the issuance of the examination report. If needed, the examiner can also call for the applicant or his agent for a show cause hearing to resolve the objections. That is why this phase is also called patent prosecution. Step 6 is where the patent is actually granted. After all the objections to the examination report have been replied to and the examiner is satisfied with the reply of the applicant, the application is put in order for a grant of patent registration. This marks the end of the procedure of registration of patent. On other hand, if the examiner is not satisfied with the reply and arguments of the applicant, then she can reject the patent application. In this case, the applicant will have to go and repeat the entire patent procedure in India to get again the patent protection. Now, if we talk about the important documents that are required for patent registration, it obviously includes application form, which is form 1, provisional or complete specification, which is form 2, abstract of the invention, which talks about the details of the invention, which is given by the inventors, power of attorney. Sometimes when the innovator or the inventor cannot come personally to apply for the patent application, the power of attorney is required. Statement and undertaking, which is form 3, declaring the inventorship of the invention and accuracy of the information provided in the application. Priority document, it is a document for any other conventional country when a patent is filed in a foreign country. Proof of right to file, you also need to present a proof that you have the right to file patent for certain device or invention that has been created. You also need to file, if you are a MSME or DPIIT recognized startup, then you can file form 28 to claim reduction in the patent charges. And also proof of fee payment is also required as a document, necessary document to patent registration. Now, if we talk about the validity of patent, it is for 20 years. It cannot be renewed after that, unlike other intellectual properties. The cost of patent registration varies from entities to entities. Like for natural person, it starts with 1600 rupees in the case of e-filing to 750 in case of physical filing when the page limit is 30. For other startup, it starts at 8000 and so on. So that is it for this video about patent registration process. Until we meet.